Hi, everyone. Welcome to video 19, Federal Courts in the United States. Um, I'm going to talk here mostly about the structure of the federal courts at the district and appellate level. The Supreme Court is the top court, and I will talk about that in the next video. So I'm splitting this up a little bit. Uh, So I'm going to start with the constitutional basis of the courts in general, and specifically the appellate and district courts and all of the other courts below the Supreme Court. Um, the Constitution says the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. Uh, so, so all of the courts below the Supreme Court are the creatures of Congress. They have a constitutional basis. Congress is given the power to create them, but the actual structure of them and the creation of those courts is entirely up to Congress. This is the only mention in the Constitution of well, the only relevant mention in the Constitution of courts other than the Supreme Court, of their creation or how they're supposed to be structured or anything. That's all left up to Congress. Um, the judges, and this includes the Supreme Court and these other courts, serve for life. The actual phrase used in the Constitution is during good behavior. So this just means as long as they're not breaking laws, basically, they continue to serve. Um, and their compensation, so their salary, once their salary is set, it can go up, but it cannot be reduced. Both of these things are intended to do two things, or to do one thing. Both of these things are geared to do one thing. A judge's job is to interpret and apply the law. The law is created by the political branches, Congress and the president. The judge's job is to interpret and apply the law impartially, equally, and not subject to politics. So these lower level judges are not supposed to be making politically based decisions, not based on they're not supposed to be making decisions that are influenced by current politics. That doesn't mean they can't have political and legal ideals, right? They can have their idea of the way the law is supposed to function, and that's fine. That's expected. But they're not supposed to be influenced by fear of losing their job. Uh, and so by taking that away, we allow them to be impartial and to stick to the law. So that's at least the theory. Um, and it generally works out pretty well. They do come in with legal philosophies, and that influences their positions on individual cases. But they're questioned about that when they take the job. And so generally, it's not 100%, but generally we have a pretty good idea what we're getting. And then once we've got it, it's not supposed to sway with the wind. It's supposed to be firm. The district courts are the lowest level courts. These are trial courts with what's called original jurisdiction, which I'll explain briefly in a moment. There are 94 of them across the country. Each of the 50 states has at least one. Some states obviously have more than one. Texas has a northern and a southern jurisdiction. Um, there's a district in the District of Columbia, which is where the nation's capital is. So that's the capital district. And there's a district in Puerto Rico, which is not a state, um, but it's a territory of a Commonwealth of the United States, and it's not far from the mainland United States. It's an island in the Caribbean, not too far from the United States. So it's not halfway across the world or something, but it's not a state. It may be a state at some point. So these trial courts, these district courts, have original jurisdiction. This means they have the authority to hear a case for the first time. um, it means that they are the court in which all trials take place. And so generally, they're the only court to make decisions about evidence, decisions on matters of fact. Um, there are circumstances where appellate courts will make decisions on matters of fact, but it has to be specifically within their jurisdiction to do so. Um, the judges in these courts make decisions on matters of law, and those matters of law are the things that typically are appealed to higher courts. Where higher courts consider evidence at all, it's usually with regard to whether the proper evidence was heard, or whether evidence may have been concealed that should not have been. But they generally don't make appellate courts generally don't make decisions about actual guilt or innocence. That's done at this original jurisdiction stage by a jury, in many cases. Um, so the deciders of fact, which are typically juries, but sometimes there's something called a bench trial, and so which is a judge acting as the jury or in place of a jury. So the deciders of fact have to determine things like, did the defendant commit the crime in a criminal trial? And that's actually got subdivisions. Like each crime has certain elements to it, and so they actually have to decide, did the defendant do this? Did they do this? Did they do this for each element of the crime? Uh, did the defendant breach the contract? If a civil case where there's a contract has been broken, the jury or judge decides as a decider of fact, did this happen? Did they break the contract? If it's a personal injury claim for some kind of some kind of an accident. These are mostly going to be state level cases, not federal anyway. But if there is a federal one, that jury or judge will decide, did the defendant cause the accident? Are they responsible or liable for the accident? So in the first case with crimes, it's are they guilty or innocent? In civil cases, it's are they liable or responsible? The decider of law has to determine how the law applies to the facts in the particular case. So one major thing is what law applies to the case. If there's if it's a criminal case, the judge needs to make a legal decision. Does does the law apply here, or is there another law that should? Um, what are the legal instructions to be given to the jury for determining guilt in a criminal case? What are the legal instructions to be given to the jury for determining liability or responsibility in a civil case? Um, are there any legal defenses that apply that the defendant should be able to put forward in a criminal case? So um, judges may decide whether there are some defenses for diminished mental capacity that can be asserted by the defense in a criminal case, and the judge has to decide whether the standards have been met to allow that defense to be applied. And if it's allowed, judges also have to decide things like what evidence can be presented to the jury, because if evidence isn't legally obtained, especially in criminal cases, it can't be presented to the jury, and judges make a decision of that. That's a legal decision to be decided by the judge. And a lot of this falls down to what precedents, that is, what prior court cases have already decided the same issues. Are there similar things that, or even almost the same things that have been decided in previous cases? And if so, that's a precedent that should apply. And that's how quite often the judges make these decisions. So the district courts are where everything starts, except for a few cases that start in the Supreme Court that I'll talk to you about next time. But after the guilt or innocence, liability, or responsibility have been decided in the lower level courts, the appellate courts review those district court decisions if someone asks them to. So someone has to actually make an appeal. It's not an automatic thing. They don't review every case. But if one of the parties to the case appeals it goes through the Court of Appeals. And these are 13 circuit courts with regional jurisdiction. It's not 13 judges. There are usually about 10 judges on the Court of Appeals, um, on each Court of Appeals. They usually hear cases in groups of 3 judges. Um, and then actually the next stage of appeal, if somebody doesn't like what the 3 judges decide, is that they can appeal it to be heard by all 10 judges, by the full court. Um, so there are actually 2 stages of appeal within the Court of Appeals, and it usually starts with just 3 judges. Um, there are 13 of these. Each of them has jurisdiction only within their own area. Uh, there are usually no new evidence or witnesses presented. Usually in an appeals court, the parties may be present, but they don't have to. Most of the people present before the bar in the appeals court are just lawyers. There may be people in the gallery watching, but the people actually before the bar are generally just the lawyers for the 2 parties, and they don't, with certain exceptions, they don't hear new evidence or witnesses. Uh, so appellate courts have appellate jurisdiction. It's probably obvious from what I've already said that appellate jurisdiction is the authority to review decisions made by lower courts. That is exactly their job, to review decisions made by lower courts. Generally only review matters of law. There are situations where they can review matters of fact. But if they're precluded from reviewing matters of fact, there's nothing they can do about it. So sometimes there will be questions about evidence that come up after a trial is over. And if it's not an area that the appellate courts, if it's an area that the appellate courts have been disallowed from reviewing, then there's nothing that those higher courts can do. It's up to the lower court to correct any mistakes on evidence. There are 3 things that they can do here. They can affirm, reverse, or remand the case to the lower court. Affirming the case means that the lower court's decision is approved. It stands. It's okay, and the appellate court has upheld it. So affirm or uphold. They can reverse it, which means that they strike it completely. That they say, no, this entire, essentially what they say is this entire trial was done in a way that we can't salvage it. Does that mean it's over? Or they, if it's a criminal matter and the person was found guilty, does that mean they're finding them innocent? No. At the local level, at the district level, the prosecutor can start over, bring back the charges, maybe amend the charges, and retry the case. But whatever was wrong that made it be reversed, they have to fix. And it's usually something that's not just a simple fix. If it's a really simple fix, they can send the case back to the lower court. So a common thing here, and it's not particularly common, but one common example here would be that there's a finding of guilt in a criminal trial, and that the judge makes a mistake in the sentencing, a legal mistake. So it can't just be a matter of they don't like what the judge did. It means that judge has to have done something that was a legal error. And in that case, they can send it back to the lower court and say, you have to correct this error in sentencing. And so they send it back with specific instructions to correct the one thing that was wrong. The decisions of these appellate courts are binding on lower courts in the same circuit. So if District 40 is in Appellate Circuit 9, and District and something happens and they make a decision, and then later District 39 has the same situation happen and they're also in Appellate Circuit 13, Appellate Circuit 9, it's still going to be binding. They have to follow that principle, that precedent. There's a really common sense reason for this, which is if it gets appealed to the same court, they're going to make the same decision. So you just follow the precedent because it's common sense. But there's also a legal reason for this, and it's called stare decisis, which is a Latin phrase that means, it's actually more complicated than this. but essentially it means the decision stands. The decision stands. So courts are supposed to follow previous decisions, and so this means that the lower courts always have to follow the decisions of higher courts, but it also means that the higher courts should follow their own previous decisions. If a judge says something and it's a legal decision, if they make a legal decision today, they should follow the same principle tomorrow, because otherwise we don't have any stability, continuity. We don't know what is legal and illegal as citizens. So judges should follow the same principle tomorrow in the similar case as they did today or yesterday. And so it's definitely binding on the lower courts to a somewhat lesser extent, but still to a pretty big extent. It's binding also on the court that made the decision. So the appellate courts are supposed to follow their own previous decisions. Um, so so back to where these jurisdictions come from, the original and appellate jurisdiction. The Supreme Court has jurisdiction in all cases affecting ambassadors, other public ministers, and consuls. So basically, the representatives, this is mostly the representatives of foreign governments who are here under uh, under the circumstances that they're working for their own government. Also, those in which a state shall be party. So, if one of the 50 United States is a party to the case, the Supreme Court has original jurisdiction. This is often when one state sues another. And yes, that does happen. It can also be cases where one state sues the federal government. It usually is not a case where a citizen of a state sues their own government, because generally those actually have to start out in state court. Uh, so, but any case where that's in federal court where one of the states is a party, the Supreme Court has original jurisdiction. So that means in these very limited cases, the Supreme Court becomes the trier of fact in addition to the appellate court. So in all other cases before mentioned, the Supreme Court shall have appellate jurisdiction both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So they have appellate jurisdiction both as to law and fact, and I just told you they very rarely, if ever, hear anything about fact, that the appellate courts at least limit themselves to just hearing matters of law. Uh, and that's because of this with such exceptions and under such regulations as the Congress shall make. Some of this is Congress having made exceptions just because they want them to be accepted, to not be heard by the appellate courts. But a lot of this has to do with just practicality. You can't have every bit of evidence reviewed by appellate courts, and you certainly can't have every bit of evidence reviewed by the Supreme Court because they'd get nothing else done. So that's where we'll pick up next class with the Supreme Court that has this limited original jurisdiction and essentially unlimited appellate jurisdiction, at least as to law. So that's it for today. Well, that's it for this video. You may watch more than one in a day, but I will talk to you next time. Bye.